All right, so this is the last part of the remedies for victims of coerced debt when it pertains to money lost from a bank account. So this is different. It's not a credit-related transaction. It is not, under the Fair Credit Reporting Act for a credit card or an auto loan or a payday loan or utility. It's not credit, it's money that a survivor had in their account that was then taken out of that account due to coerced debt. And the law that applies to this is the federal law, the Electronic Funds Transfer Act. It is found at 15 USC 1693 et seq. And it applies to consumer deposits and savings accounts, so bank and bank-like accounts, which means I'll go through it in a second, the type of accounts, but it generally, bank-like accounts means things like a Cash App account, PayPal, Venmo, things like that. And it provides protections for unauthorized use in other areas. The EFTA rights cannot be waived. That's found at 15 USC 1693L. And if you want to know more about what unauthorized use is and those protections, fantastic resource here is the CFPB's EFTA FAQs. For some reason, you can't click on that link. You can just Google, you can go to consumerfinance.gov, which is the CFPB's website. And on the search button, you can put EFTA FAQs and it will produce that document. So what types of accounts and transactions are covered by the EFTA? So as I mentioned, this is demand deposit, savings, assets accounts, but these have to be for personal, family, or household use. So it can't be a business bank account. It has to be a consumer bank account because the EFTA only applies to consumer accounts. It covers electronic funds transfers or EFTs, and EFTs are here. Here are some transactions. Sorry, one second. EFTs are electronic funds transfers, are generally defined as something that originates from an electronic terminal or some electronic transaction processing. And so it's not cash, it's not check, because those are all, those are paper. So it has to be electronic. The examples that are provided are ACH transactions and debit cards. So again, if you are, if the debit card's being used at the ATM to withdraw money, that would count. If the debit card's being used at a point of sale when you're purchasing something, you're using your debit card. Mobile peer-to-peer apps like PayPal, Venmo, Cash App, and Zelle. And prepaid and payroll cards, all of these are covered by the EFTA. The exceptions, as I mentioned, checks, because it's paper. If it initiates through a telephone call between the consumer and the financial institution, that would also be exempted. And then if it's a pre-authorized transfer, less than $100 million, and that, is kind of outside the scope of this presentation, because if it's pre-authorized, it probably wouldn't fit under the unauthorized use provision. But one that is really important here are wire transfers. So unfortunately, this is a loophole in the EFTA. Even though wire transfers are initiated electronically, back when the law was passed in the 70s, generally wasn't something that consumers used. It was more business to business. And then, they said they exempted it. It said wire transfers that are utilized through services that are not for consumer use. And then the Federal Reserve Board went ahead and in the implementing regulations, which is Regulation E, said that includes services like Fedwire, SHIPS, and SWIFT. So pretty much all bank-to-bank wire transfers are exempted from the EFTA. But certain wire transfers, like if you see here on the slide, Western Union, MoneyGram, or even international transfers, which are called remittances, those actually are covered by the EFTA. There are some rules that differ if they're international, but if that happens, feel free to reach out to me or to TAP if you have questions about whether this you could utilize this provision or not. So it provides strong protections for unauthorized use. That then is kind of similar to all the other statutes, basically gives the consumer the right to dispute it, to have an investigation, and in this case, to have the money reimbursed or basically credited back to the consumer's account if it's unauthorized. So that's why we wanted to mention this, because if this has happened to a survivor, having money in hand is so important. And so being able to help them get money back that was taken by their abuser is a really powerful remedy and tool. So what's really important here to determine whether or not you can use this to help a survivor is whether the transaction was actually unauthorized. So the definition is written right here, and it has to be initiated by someone other than the consumer who does not have actual authority. There's no implied or apparent here. It's just actual authority to initiate the transfer, and the consumer received no benefit. So it has that similar language to the TILA's unauthorized use provision, that they could not have received a benefit from it. But again, if this was taken from them by the abuser, it's likely they're not going to have received the benefit of the money that they lost. And so the challenge here is if it was a joint account. So if the survivor and the abuser had a joint account, they won't be able to use this because he had actual authority to be able to take money out of that account, to transfer money out of the account because it was a joint account. So again, this likely will only happen in the scenario where it is the survivor's individual account that the abuser did not have access to, wasn't granted access to, wasn't an authorized user, or anything like that. So important information about unauthorized use. These are in the FAQs, the CFPB's FAQs and Regulation E as well, which says consumer negligence plays no role. So if I, as the survivor, have my debit card in my wallet and I am very forgetful, and so I put my PIN number on a sticky note and then stick it to my debit card in my wallet, and then the abuser steals it, takes it from me and then uses it, I still cannot be held liable for that because consumer negligence plays no role. If it was unauthorized, then I have the right to benefit, of the benefits of this statute and the remedies that it provides. In this dispute mechanism for the error resolution procedures, the burden is on the financial institution to prove it is authorized. Unfortunately, in practice, they don't often get this right. So it necessitates multiple disputes and sometimes a complaint with the CFPB. But I can't prove a negative. So I can't prove that it wasn't me. It's on you to prove it was me. And so that's why it's so important when you dispute to ask for, information that they rely on in the investigation. If, if the money was taken from an ATM in Dallas and I live in Austin, then, they should be able to show that in their investigation. And I should be able to say, like, I couldn't have done that. I don't live in Dallas. I wasn't in Dallas. Prove that I was in Dallas, things like that. The CFPB does say that refusing to reimburse the consumer for unauthorized EFT initiated by a person who obtained access to the device through fraud or robbery is an EFTA violation. So that includes fraud. And so I would argue that if it was through manipulation or deception by the abuser, and it was, fraud in that sense, that it would be covered under the unauthorized use provision of the EFTA. The consumer receives no benefit. There's not very much case law on this at all. Part of that is because so many of these cases end up going to arbitration. But it is similar to TILA's unauthorized use provision. And so again, if most of the times you're going to be asserting this for coerced debt survivor is when they didn't receive that cash, they didn't receive that money, they obtained no benefit. But there's some examples here of the FTC where they, they unwanted skincare products that they got, right? Like they received them, but they received no benefit because they didn't want it. And so debits for that can be considered not a benefit. So it may be fact specific if the abuser used it and obtained that money. You can argue that she didn't receive a benefit even if it was something that, like, he bought for her, but she didn't use, didn't want. What is not considered unauthorized. So if it's initiated by the survivor, even if the abuser deceived or manipulated her to do it. So again, if in the context of there had, this happened where the survivor is the only person who is working, the paycheck is going into a joint account, and then the abuser says you need to use that money to make a payment on a debt that was his, not hers. She's not liable for at all. But he says you have to do this. Or if he himself, again, if he's an authorized user, makes a payment himself, there's no unauthorized use there because he's an authorized user. He's a joint account holder. But if he tells her, you need to do this, or I'm going to use, and she initiates the transaction, then she would not have the benefit of the unauthorized use. However, in that context, if he takes her debit card and initiates that transaction to pay off his debt, then it would be considered unauthorized because she did not initiate the transaction. The electronic funds transfer by a person to whom the consumer furnished the access device, even if it exceeds their authority. So this would be in the context of, again, the survivor willingly provide her credit card to the abuser to use it to purchase gas, for example. And then in addition to purchasing gas, he also bought himself some liquor and some food at the 7-Eleven. That would not be unauthorized because presumably she gave them that access device, even though, and gave permission to the access device being the debit card, even if he exceeded the authority. The access device, as I put here, could be the debit card or even the account number, routing number information that allows them to initiate a transaction. But you can consider, even though under the coerced piece, it wouldn't fit the unauthorized use definition of, of the EFTA, you may be able to use the debit card abuse penal code provision if there was no express consent. You may be able to get a police report there and use that to dispute it with the bank. If the EFT isn't authorized, what then? So this is where the dispute procedures kick in, what are called the error resolution procedures. So there's all different types of errors. We're focusing on the unauthorized use. I've listed some other ones here. So you will then have to dispute it. There's no requirement under the statute of how that notice is given. So you don't have to send it in writing. It can be oral. Again, as with all of these, best practices to always send it in writing. Follow up, because time is of the essence, dispute ASAP by phone or by going into the branch or whatever it may be, but then always follow up in writing. You have to dispute timely in order to be provided with credited your account back after that unauthorized use. So generally, if the debit card wasn't stolen or the access device wasn't stolen, then you have 60 days of when you receive the statement showing the unauthorized use. So that would be, again, if to May 1, the abuser takes, logs into the account, does a Zelle transfer to his account without her knowing about it or doing it, her individual account, his individual account. I have from 60 days from May 1, because that's when, actually 60 days from when that statement with that May 1 charge appears. So generally statements are every 30 days. So it may be that the statement that has that May 1 Zelle transfer is May 15, maybe May 30th, maybe it's June 1, whatever that date is. Whenever it first appears, then it's 60 days from that date to dispute it. After you dispute it, they have to give you a response within 10 days. So they basically have to conclude the 10 days. The investigation within 10 days. However, they can take up to 45 days to investigate it, but only if they credit your account back that amount. So let's say it's $1,000 Zelle transfer that you're disputing. If within 10 days they don't conclude the investigation, they have to recredit your account that $1,000 while they're pending their investigation. So as you see here, even if you dispute it orally, they may require you to follow up in writing. This generally is what I've seen happen. And they may actually ask for more information. They may ask for a police report. They may ask for other things. But they have to tell you where to send it and how to send it at the time that you're disputing it. The notice, even though there's no, form required or anything like that, it does have to have enough information for the bank to do an investigation. So the account holder name, their number, the account number, which error it is, like, which charges it is, how it occurred, and the reason you believe it was an error. So in this case, the error is the unauthorized use. Although a police report is not required, and it's very clear in regulations that it's not required, they almost always ask for one. So best practice is to get a police report. But again, because time is of the essence, if you don't have one yet, I would encourage a survivor to call, to dispute, and then go get the police report afterwards and follow up with the police report. You want to ask for all the documents they use to investigate, again, to make sure that you have the same information that they have. So again, the liability issue, why time is of the essence. I said, if the device wasn't stolen, you have 60 days to dispute it from when it appeared on that statement, and you have zero liability on any of those unauthorized use of that $1,000 Zelle transfer if you report it within those 60 days. If you report it after the 60 days, so again, let's say that May 1, $1,000 Zelle transaction first appeared on May 15. You have 60 days from May 15 to dispute it. If you don't, then do it by that 60 days, and you do it 70 days afterwards, then you're not liable for that first $1,000 that happened on May 1st, but you may be liable for any preventable charges after those 60 days. So let's say the abuser does another Zelle transfer on, let's say the 60 days is May, June, July. Let's say the 60 days is August 1st. And so he makes a Zelle transaction on August 2nd, another $1,000 Zelle transaction, and I don't dispute until August 15. Well, I won't be held liable for the first transaction that was within those 60 days, but because I didn't do it within the 60 days, that Zelle transaction afterwards, on August 15th, I would be held liable for, because it was a preventable charge that I didn't just timely dispute. Now, if the access device was lost or stolen, so this would mean, for example, that the debit card was stolen, or I gave someone my account information, something like that, and then I learned, I then have 2 business days from learning about the unauthorized use to dispute it. And so, in order to make sure that I'm not responsible for that amount. If I do report it within 2 business days of learning it, then the most I can be held liable for is $50. So again, let's say May 1st, I realize that my debit card is missing. I check my bank account information online, and I see that there was, $600 worth of transfers that were made when I first discovered this May 1st. So I have 2 business days from May 1st of when discovering my debit card is stolen, to inform the bank about those $600 charges. And the most I can be held liable for is 50 days. If I don't report it within those 2 business days, but I do report it within 60 days of the bank statement, then the most that I can be held liable for is the $50 and any debits that are made after 2 business days until the notice is given. So again, in this example, May 1st, I learned of those $600 transactions. So I can't be liable for the $600 transactions if I report it within 60 days. I can only be held liable for $50 of that 600. But then if after I dispute, but then after, May 1st is when I learned of it, right? So May 2nd, I don't dispute it. May 3rd, I don't dispute it. May 4th, I don't dispute it. I don't dispute it until, June. Any transactions that happen after May 3rd, I would be held liable for up to a maximum of $500. So again, not liable for the initial 600, only liable for the $50 there. But then if after May 3rd, there's another $200, another $400, I could be held liable for that. Again, maximum of $500. So that's why time is of the essence. That's why it's so important to dispute this as soon as we find out about that. Again, worst case scenario, as long like you're like, I can't, this is too much. I can't even. Just to simplify it, if the consumer disputes it within 60 days of when it appears on the statement, whether the device was stolen or not, the most they could be held liable for is $50. So if the device was stolen, $50. Device wasn't stolen, $0. But that's only if you dispute it within the 60 days of the statement. And again, if it was stolen, they may have more liability, but that's only if more charges happen after the initial. So that's a lot to think about, but at the end of the day, dispute as soon as you can. And, again, if you have, if this is difficult, you're not sure how to advise the consumer, feel free to reach back out to TOP. So practical tips, again, kind of bringing it back. Notify bank as soon as possible. You need to do it within 2 business days if it's lost, or 60 days of receiving, for you not to be held liable for any charges, or the survivor not to be held liable. Can be by phone, in person, at the bank. Make sure that the survivor puts the date, the time, location, employee that they talked to, the number they called, any of that information, so that, if there's any problems, you have that information to be able to provide to anyone, the CFPB, if you're filing a complaint with them. Best practice is follow up in writing. Best practice is also to help the survivor safety plan. So, that would be canceling a card, getting a new card issued. It may even be closing an account and opening a new account. It may be redirecting any deposits. So, if you don't want to close the account, but you don't want to, you want to order a new debit card, but you want to make sure that no future money can be taken from there, open a new account, have all new deposits in that new account, paycheck, things like that. So those are some things to think through. Just to wrap up, again, as I said, the bank has to report the results within 10 days or take up to 45 days, but only if they recredit. Again, the burden is on the bank and the investigation has to be reasonable. Again, I mentioned this before, but according to the CFPB, the bank can't require the consumer to file a police report or notarized affidavit. And they cannot require the consumer to try to dispute it first with the merchant before starting an investigation. But as a best practice to try to eliminate all the barriers as possible, often I will help the survivor do this anyway. If there was an error, then they have to correct it within 1 day. So after the investigation, they have to correct it. If they give provisional credit, but there was no error, they can reverse that credit, but have to give 5 days of notice of honor or payments for 5 days. And this may trigger overdraft. So what that means is, if they say they conclude the investigation in 45 days, they had given them provisional credit after 10 days, and that provisional credit was, that $600 unauthorized charge. If they conclude, sorry, you did authorize it, they have to give them at least 5 days notice beforehand. They also have to give consumer the written explanations of the findings, right to request those documents, and those documents have to be in understandable form. So I'm going to talk through this really quickly, which is the scenario. This is a little different from James and Maria. Susan was married to Ivan for 20 years. After the birth of their first child, he became emotionally abusive. After the birth of their third child, he became physically abusive. He lost his job, and Susan went to work as a custodian. He required her to deposit her paycheck into a joint account and prevented her from accessing the funds. When Susan fled for her safety, she opened a new bank account with the same bank, but only under her name. Ivan found out about the account and went to the bank branch and transferred money from her new account to the joint account. What legal remedies does Susan have? So here, because there's a new account that is only under her name, he's not an authorized user, he's not a joint account holder. How he found out about this account could have happened at the branch. He could have gone in and said, hey, my wife, you see, we're both on the account. However, he found out about it. If he then transferred that money using an electronic funds transfer. So again, if he did it through an ACH transfer through a, which is basically an account to account transfer, that he, if he logged on to his account and did that way, he was able to access her account somehow and to do that through her account, or even if he did it through getting onto her account and having that be sent to him through Zelle, or through he logged into PayPal and somehow had her account information, and so had that money be transferred from her new account to his. Like all of those examples that I'm giving is basically if it falls under the definition of an EFT, then she would have the error resolution remedies for unauthorized use under the EFTA, and she would be able to dispute it with her bank as long as she does it timely within 60 days of when it first appears on her account, and to have that money recredited to her account. So that was a lot that we talked about today, a lot of the resources that we talked about, during the presentation of the coerced debt assessment tool, of the drop-down menu for the types of accounts and next steps and who you disputed it and where, should be available on our website. But there's also other types of resources available. The Center for Survivor Agency and Justice has coerced debt screening tool as well. There is a listserv if you want, to talk to other lawyers who are helping survivors of coerced debt at talkcoerceddebt@csaj.org. And then we also, the Texas Council on Coerced Debt has a fantastic toolkit on coerced debt where you can get more resources and information. For example, our toolkit, which is on financialabusehelp.org, has 4 different tools on understanding what coerced debt is, protecting, discovering, and disputing. So all of the things that we spoke about today, there's sample dispute letters, there's checklists, things like that you can look through. So hopefully this presentation provided you with a lot of information to help survivors of coerced debt dispute their debts before applying for a 521 or even after applying for a 521. And you can watch that presentation on how to obtain a 521 with other resources that are available to you. If you have any questions, feel free to reach back out to TAP, or you can email me at csanchezadams@nclc.org.